Good morning. My discussion for today is Module 7, Concepts and Sociology of Law. Okay, so first, what is law? Law is passed because of the consensus of the will of the public. In the Philippines, we have a bicameral system of legislation. It is called bicameral because it is composed of two houses. Okay, the Senate and the House of Representatives. Okay, we have three major divisions or branches in the government. The executive, okay, vested on the office of the president. Okay, executive yun yung kapangyarihan or power ng presidente. Okay, siya yung may karapatang mag-execute ng law. Okay, the legislative, cited and explained above, and the judiciary, okay, vested on the Supreme Court. Ang may hawak or may power naman ng legislative is our Senate and the House of Representatives. While judiciary, okay, vested on the Supreme Court. Supreme Court, ayan yung mga judge na tinatawag natin. We are being represented by the legislative branch in making the laws. Making the laws, kaya siya tinawag na legislative. Sila ang tagagawa ng batas. Okay, legislative. Okay, then judiciary, ayan naman yung pag-aaralan ng Supreme Court, pag-aaralan niya ng mga judge. And then, once na napag-aralan, i-execute ng presidente, pipirmahan niya, siya ang mag-execute ng law. So, we have three major divisions or branches of the government. Huwag niyong kakalimutan, executive, legislative, and the judiciary. Okay, ang may hawak ng executive is the president, legislative is the Senate, okay, and then the judiciary is Supreme Court. Okay, so early laws naman tayo. So we have early laws worldwide. Okay, we have the so-called Code of Hammurabi. Yan yung for an eye to eye and a tooth for a tooth. Okay, doon yan sa Babylonia noong 1700 BC. And then we have the so-called Mosaic Code of Israelites. Okay, noong 12,000 BC. Then we have the so-called Draconian Code from Greece noong 17th century. Hindu Code of Manu in India. Quran, syempre, Islamic Society. Then Law of 12 Tables by the Romans. And Sumerian Code, okay, doon sa Sumer nung 3,500 BC. And the Law of Moses noong 1,500 BC to 1900 BC. So, yan yung mga early laws natin. Okay, yan yung mga law natin noon. Okay, entire na worldwide. Next, introduction to criminal law. So first, criminal law is that branch or division of law which defines crimes, threats of their nature, and provides further punishment. Ayan po yung tinatawag nating criminal law. Okay, siya yung nagdi-define ng crime na ginawa. Okay, kung ano din yung nature ng ginawang krimen, at siya din yung nagpro-provide ng punishment. Siya din yung nagbibigay. Okay, yan yung tinatawag nating criminal law. Take note guys, ito ay isang branch or division of law. Okay, so next, we have theories of criminal law. We have the classical theory and the positivist theory. First, classical theory, man is essentially a moral creature with an absolute free will to choose between good and evil, and therefore, more stress is placed upon the result of the felonious act than upon the criminal himself. So, na-discuss ko na yan last module natin, the classical theory. Okay? So, sa classical theory, okay, meron tayong free will na mamili. Okay, between good and evil, kung ano yung gagawin natin doon. Okay? Next, we have the so-called positivist theory. Man is subdued occasionally by a strange and morbid phenomenon which conditions him to do wrong and or contrary to his volition. Okay? Ayan naman yung sa positivist theory. Okay? Dito naman, okay, sabi dito, man is subdued occasionally by a strange and morbid phenomenon, which conditions him. Okay? Para lang din siyang classical. Meron lang din siyang, merong mga sitwasyon or mga kondisyon na gagawa siya ng mali. Okay? In contrary doon sa volition niya o doon sa kagustuhan niya. For example, gusto niyang gumawa ng mabuti. Okay? Pero nandoon siya sa sitwasyon or kondisyon na gagawa siya ng mali. Kailangan niyang gumawa ng mali. Okay? So, yan naman sa positivist theory. Next, we have the so-called eclectic or mixed philosophy. Okay? This combines both positivist and classical thinking. Crimes that are economic and social in nature should be dealt with in a positivist manner. Thus, okay, the law is more compassionate. Heinous crimes should be dealt with in a classical manner, thus capital punishment. Siyempre, kung mas malalang krimen yung ginawa mo or mas kahindik-hindik na krimen, heinous nga, okay? Siyempre, ang ipapataw sa'yo na punishment is the capital punishment. Okay? Kung noon ang capital punishment is death penalty, ngayon life imprisonment na. Okay? Or yung tinatawag nating reclusion perpetua, okay, reclusion temporal, may iba't iba tayong punishment. Pero dito, kapag nag-combine ang positivist and classical thinking, tinatawag siyang eclectic or mixed philosophy. Next, okay, doon naman tayo sa basic maxims in criminal law. Naalala niyo ba yung palagi kong sinasabi na there is no crime if there is no law punishing it? So, tignan natin kung paano siya or kung ano yung kabaliktaran naman niya in a Latin word. Okay? So, first, doctrine of pro reo. Ano nga ba itong tinatawag nating doctrine of pro reo? Okay? Whenever a penal law is to be construed or applied and the law admits of two interpretation, guys, take note, two interpretations, one lenient to the offender and one strict to the offender. Okay? So, dalawang interpretation yan. Okay? Or sabihin na natin, for example, dalawang tao. Pwedeng yung isa maging lenient dun sa offender, yung isa naman maging strict. That interpretation which is lenient or favorable to the offender will be adopted. So, nabasa nyo, ang kukunin, okay, or ang i-a-adapt is the lenient one. Okay, yun ang magiging favorable doon sa offender or doon sa gumawa ng krimen. Okay, yun ang ibig sabihin ng doctrine of pro reo. Next, eto na guys, yung sinasabi ko, nolium crimen, nolia poena sine lege. Okay, there is no crime when there is no law punishing the same. Okay, this is true to civil countries, but not to common law countries. Okay? So, totoo to guys, sa mga civil law countries. Pero kapag yung sa common law countries na, okay, hindi yan ina-adapt. Okay? Yung nolium crimen, nolia poena sine lege. Because of this maxim, there is no common law crime in the Philippines. Okay? No matter how wrongful, evil, or bad the act, if there is no law defining the act, the same is not considered a crime. So, kagaya ng binasa ko, guys, kapag, okay, kahit gaano siya kasama or gaano siya kamali yung ginawa niya, as long as walang nagdi-define na law doon sa krimen na ginawa niya, okay, hindi yun makukonsidered, hindi yun makukonsidera as crime. Okay, kaya nga tinawag nating nolium crimen, nolia poena sine lege. Okay, hindi siya, walang magiging krimen. Okay, kung wala namang law na nagpapunish dito. Okay? Like, for example, noon, the so we call the computer law, something like that. Eh, di ba may gumawa ng virus noon? That time, wala pa namang law about computer. Di ba? About computer, may tawag dun guys, kaya nakalimutan ko. So, ibig sabihin, hindi siya, Filipino yun guys. Filipino siya na gumawa ng virus. Okay, so, wala namang law pa noon about doon sa ganon. And then, so, ibig sabihin, hindi siya nakulong. Pero kinuha siya ata ng FBI sa ibang bansa. Para siya ang, kinuha siya para magtrabaho doon. Hindi ko kilala kung sino yung lalaki. Pero nakagawa siya noon ng virus. Okay? Next. So, next is actus non facit reum nesiminset rea. Okay? The act cannot be criminal where the mind is not criminal. Guys, take note. Yung action cannot be criminal. Okay? Kung yung mind mo is hindi naman criminal mag-isip. Okay? This is true to a felony characterized by dolo, but not a felony resulting from culpa. This maxim is not an absolute one because it is not applied to culpable felonies or those that result from negligence. Okay? So, yan yung tinatawag nating actus non facit reum nisi mens sit rea. Okay? Then, next, we have the so-called utilitarian theory or yung tinatawag nating protective theory. The primary purpose of the punishment under the criminal law is the protection of society from actual and potential wrongdoers. The courts, therefore, in exacting retribution for the wrong society, should direct the punishment to the potential or actual wrongdoers. Yun naman talaga ang ginagawa natin. Direkta yung punishment na binibigay doon sa nagkamali o doon sa nakagawa ng krimen. Since criminal law is directed against acts and omission which the society does not approve, consistent with this theory, the mala prohibita principle which punishes an offense regardless of malice or criminal intent should not be utilized to apply the full harshness of the special law. Okay? So, yung utilitarian theory and protective theory, okay, dun sa next slide natin or sa mga susunod na slide, matatakel natin yan. Okay? Pero ang sinasabi lang naman dito sa utilitarian or protective theory, yung punishment, okay, doon sa gumawa ng krimen or doon sa nakagawa ng krimen, direkta na siyang ibibigay sa kanya. Okay? Regardless of malice or criminal intent, guys. Take note for that. Okay? Next. So, sources of criminal law tayo. Okay? We have two sources. The revised penal code and the special penal laws. Okay? Special penal laws, guys, acts enacted of the Philippine legislator punishing offenses or omissions. Okay? The last, I think, sa mga previous modules natin, natakal na natin ang tinatawag nating revised penal code and special penal laws. Okay? So, construction of penal laws tayo. Criminal statutes are liberally construed in favor of the offender. This means that no person shall be brought within their terms who is not clearly within them, nor should any act be pronounced criminal which is not clearly made so by statute. The original text in which a penal law is approved in a case of conflict which an official translation, interpretation by analogy, has no place in criminal law. Okay? So, yan lang naman yung construction ng penal laws natin. Okay? So, next tayo. Okay guys, eto na yon, si mala ense and the mala prohibita. Okay? So, sabi dito, violations of the revised penal code are referred to us as malum or malum inse or mala inse, which literally means that the act is inherently evil or bad or per se wrongful. Kapag sinasabi nating mala inse, ibig sabihin yung ginawang action, yung ginawang krimen is evil or bad. Lahat naman ng ginagawang krimen is mali or bad. Okay? Or wrongful or mali. Okay? On the other hand, violation of special laws are generally referred to as malum prohibita or mala prohibita. Okay? Note, however, that not all violations of special laws are mala prohibita. Okay? Hindi lahat ng violations under special laws is a mala prohibita. While intentional felonies are always mala inse, it does not follow the prohibited acts done in violation of special laws are always mala prohibita. Even if the crime is punished under a special law, if the act punished is one which is inherently wrong, the same is mala inse, and therefore, good faith and the lack of criminal intent is a valid defense. As I've said, a valid defense unless it is the product of criminal negligence or yung tinatawag nating culpa. Okay? Likewise, when the special laws require that the punished act be committed knowingly and willfully, criminal intent is required to be proved before criminal liability may arise. Okay? Kailangan muna nilang i-prove bago nila tahakin or itakal naman yung tinatawag nating criminal liability. Okay? When the act penalized is not inherently wrong, it is wrong only because it punishes the same. So, yan ang ibig sabihin ng mala inse and mala prohibita. Next, ayan guys. So, nakikita nyo naman kung ginanyan ko na siya. Okay, the mala inse sa kabila and then the mala prohibita naman sa kabila. So, sa mala inse muna tayo. By kwan tayo guys. Malum inse, criminal liability is based on the moral trait of the offender. That is why liability would only arise when there is dolo or culpa in the commission of the punishable act. In malum prohibitum naman, the moral trait of the offender is not considered. Okay? It is enough that the prohibited act will be voluntarily done. So, doon sa malum inse, yung moral trait, okay, ibinabase nila doon. Pero dito sa malum prohibitum, hindi po yan kailangan. Hindi yan kinoconsider. Next, good faith in malum inse or lack of criminal intent is valid defense unless the crime is result of culpa. Kabila naman, good faith is not a defense. Okay? So, makikita niyo na kung anong pagkakaiba dyan. Then, next, number 3, the degree of accomplishment of the crime is taken into account in punishing the offender. Thus, there are attempted, frustrated, and consummated stages in the commission of the crime. Yes. Okay? We have attempted. Attempted, yun pa lang yung pinag-iisipan mo pa lang. Gusto mo pa lang siyang gawan ng krimen. Okay? Frustrated. Okay? Ayan na yung meron ka ng parang porsigido ka na. Okay? Then consummated. Gagawin mo na yung krimen. Na-consume na. Okay? Consummated. Stages in the commission of the crime. Then, sa malum prohibitum naman, the act gives rise to the crime only when it is consummated. Guys, take note. Tsaka lang mag-a-arise yung crime kung ang ginawa is consummated, natapos nang gawin yung krimen. There is no attempted or frustrated stages. Hindi siya kailangan. Hindi kailangan ang attempted and frustrated. Next, sa malum inse ulit tayo, penalty may vary depending on the presence or absence of circumstances. Okay? Sa malum prohibitum naman, mitigating and aggravating circumstances are not taken in any account in imposing the penalty. Circumstances is yung tinatawag, mitigating and aggravating circumstances. Pero meron pa tayong iba't ibang circumstances, guys. Jimaa. Okay, matatakal nyo yan sa law 1 ninyo. Okay, yung tinatawag nating circumstances, the jimaa. Next, okay, characteristics of criminal law. So, characteristics of criminal law tayo. We have general, territorial, and the other one. But una muna natin is general. Okay? General in that it is binding to all persons who reside or sojourn in the Philippine territory. Incidentally, these general characteristics of criminal law is not applicable to the following instances. Number 1, treaties and laws of preferential application. B, under the principles of public international law. General kasi, guys, ibig sabihin nandun ka lang sa country, nandun ka lang sa Pilipinas. Okay? In general yan. General ang tawag doon. Pero kapag treaties and laws of preferential application and principles of public international law, okay, hindi na po yan applicable sa criminal law natin. Okay? Next, we have the territorial. That is, it undertakes to punish crimes committed within the Philippine territory. Okay? Except the following. Guys, it undertakes to punish crimes committed within the Philippine territory, except the following. First, should commit an offense while on Philippine ship or airship. B, should forge or counterfeit any coin or currency of the Philippines or obligations and securities issued by the government of the Philippines. C, should be liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the preceding number. Letter D, while being public officers or employees, should commit an offense in the exercise of their functions. And lastly, should commit any of the crimes against national security and the law of nations defined in the revised Penal Code. So, dun pa lang sa tinatawag nating territorial, okay, it undertakes to punish crimes committed po within the Philippine territory. Okay, yan yung tinatawag nating territorial. Okay, alam kong naintindihan nyo pa lang yung nag-commit na sila within, okay, the Philippine territory. Next, prospective. Ano naman yung tinatawag nating prospective? In that, a penal law cannot make an act punishable in a manner in which it was not punishable when committed. The characteristics is not applicable whenever a new statute dealing with crime establishes conditions more lenient or favorable to the accused, but this exemption has no application. First, where the law is expressly made inapplicable to pending actions or existing causes of action, and B, where the offender is a habitual criminal under Rule 5 of Article 62 of the revised Penal Code. So, yan naman yung prospective natin. A penal law cannot make an act punishable in a manner in which it was not punishable when committed. Okay? Next, elements of crime tayo. Ano nga ba yung mga elements of crime? First, act or omission. Act or omission be voluntary. Act or omission be punishable by law. Okay, first tayo, act or omission. Acts are positive while omissions are negative. A wrongdoer is therefore guilty of an act when he does that which he should not to do. And he is guilty of a crime of omission when he leaves undone that which he ought to do. Okay? So, yan po yung act or omission. The positive, ang act is the positive and the negative is the omission. Act or omission be voluntary. The act or omission must be voluntary in order that a person may be criminally liable for it. Voluntariness in turn presupposes freedom of the will, intelligence, and intent. Hence, there is no freedom of the will if one is impelled by an irresistible force, nor, is there intelligence when the act is committed during insanity. There is no intent when the occurrence is the result of unavoidable incident. So, wala daw intent, kung ang nag-occur or ang result is an avoidable accident or during or kapag kinukumot mo yung act is, wala ka sa tamang pag-iisip. Okay? Next, act or omission be punishable by law. As a general rule, a crime consists of 1, the criminal act, then 2, the criminal intent, otherwise known as the mens rea. The crime is the action or omission which the law forbids, and mens rea is the intending to do what you know. So, yan naman yung act or omission by punishable by law. Okay? Mas maiintindihan nyo yan once na nakuha nyo na yung subject nyong law 1. Or mas maiintindihan nyo pa ng maayos. Next, we have stages in the commission of a crime. Sabi ko nga, stages, attempted crime, frustrated crime, and consummated crime. So, attempted muna tayo. There is an attempt when the offender commences the commission of a crime directly by overt acts, but does not perform all the acts, the execution of which should produce the felony by reason of some causes or accidents other than his own spontaneous decision. Okay? Kapag attempted crime, guys, there is an attempt. Okay? When the offender, kung yung offender is nag-commence na, to the commission of the crime directly by overt acts, but does not perform. Hindi niya ginawa lahat yung acts, in the execution. Okay? Frustrated crime naman, there is frustrated crime when the offender performs all the acts of the execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of his will. So, frustrated, nagawa na niya, na-perform niya na lahat ng action, na-execute niya na lahat. Consummated naman, a crime is consummated when the offender has performed all the acts of execution and the felony is actually accomplished. Sa frustrated kasi, yung felony, hindi pa accomplish, hindi pa niya na-accomplish. Pero kapag consummated na-perform na din niya lahat, and the felony is actually accomplished. Natapos po. Okay? So, next tayo. Criminal Law Book 2. Okay? In Criminal Law Book 2, we have against national security and law of nation, against fundamental law of the state, against public order, public interest, public morals, committed by public officers, against person, personal liberty and security, properties, chastity, so yan yung mga nasa criminal book 2, yan yung mga krimen, in doon tayo sa national security and law of nation, meron pa po yung mga crimes na nakapaloob dyan. Lahat yan, meron pang mga crimes na nakapaloob dyan. Hindi lang yung crimes against person, hindi. Crimes against national security, may mga crime na nakapaloob dyan na pwedeng ipataw sa inyo. Next, special penal laws. Special penal laws, apart from the crimes penalized in the revised penal code, several other pieces of criminal legislation have been passed penalizing acts such as illegal possession of traffic of dangerous drugs, money laundering, and illegal possession of firearms. These are called special laws. Ayan yung mga nakapaloob sa special laws natin. Okay? And they form part of the Philippine criminal laws. There are certain differences between crime punished under the revised penal code and special laws. Yes. Okay? May difference po yung dalawa na yan. Violation of the crimes listed in the revised penal code are referred to as mala inse, which literally means that the act is inherently evil or bad or wrongful in itself. On the other hand, violation of penal laws or special penal laws are generally referred to as malo or mala prohibitum or mala prohibitum, or an act that is wrong because it is prohibited. Pinagbabawal. Okay? Thus, no criminal intent is needed in order to find a person liable for crime punished under the special penal laws. Okay? Hindi na kailangan ng criminal intent, okay, in order para maging liable yung person na yon doon sa gumawa doon sa mga nasa special penal laws like possession of firearms. Okay? Sa revised penal code kasi guys, ang merong mga krimen is murder, homicide, okay? Crimes against person yon. Yeah, I think. Kung hindi ako nagkakamali. Okay? So, for crimes punished under special laws, as long as the act is committed, then it is punishable as crime under law. Ayan po yung pagkakaiba ng revised penal code na tinatawag natin and the so-called special penal laws. Mala inse, revised penal code. Mala prohibitum or malum prohibitum is special penal laws. Ang mga nasa special penal laws na crime is illegal possession and trafficking of dangerous drugs, money laundering, illegal possession of firearms. Okay? In revised penal code, yan yung nakita nyo dun sa criminal book 2. Okay? Yan yung mga pwedeng or mga crime na nandoon. Next, note, however, that not all violations of special penal laws are mala prohibita, while intentional felonies are always mala inse. It does not follow the prohibited acts done in violation of special laws are always mala prohibita. There are some important distinctions between crimes punishable under the revised penal code and special laws or special penal laws. One of them is that in crimes punished under the revised penal code, the moral trait of the offender is considered. Okay? This is why liability would only arise when there is criminal intent or negligence in the commission of the punishable act. In crimes punishable under special laws naman, the moral trait of the offender is not considered. Kagaya ng sinabi ko kanina doon sa previous slides natin. It is enough that the prohibited act was voluntarily done. So, ayan, nilagay ko din dito yung pagkakaiba pa rin ng revised penal code and the special penal laws. Next, criminal procedure. We have the criminal law 1, criminal law 2, and the criminal procedure. Okay? Matatakal nyo, ay makukuha nyo ring subject yan, criminal procedure. Method fixed by law for the apprehension and prosecution of a person who is accused of crime and for his punishment whenever convicted. So, we have Rule 110. Okay, prosecution of offenses, filing. Ito yung cycle. Okay? Kapag nagawa yung crime, and then, yung nagawan ng crime, or yung pamilya nung nagawan ng crime, ito ang gagawin. Mag-file sila ng criminal case. Then, Rule 111, filing of civil case. Kapag na-file ang criminal case, susunod ang civil case. Rule 112, preliminary investigation, guys. Preliminary investigation, inquiry, or proceeding to determine if there is sufficient ground to engender a well-founded belief that a crime cognizable by the RTC or the Regional Trial Court has been committed and that the respondent is probably guilty thereof and should be held for trial. Preliminary investigation, yan pa lang yung mag-iimbestiga sila kung talagang may nangyari bang krimen na ganito. Okay? Para malaman kung yung gumawa ng krimen is guilty. Okay? And doon magpo-proceed doon sa trial na tinatawag. Rule 113, arrest. Yan na yung taking a person into custody in order that he may be bound to answer for the commission of some offenses made by an actual restraint, okay, of the person or by his submission of the custody. Yan din yung ibig sabihin ng arrest. Then next, Rule 114, bail. Okay, it is the security given for the release of a person in custody, okay, to be furnished by him or a bondsman, condition upon his appearance in court as required under the following condition. Bail, ayan yung, meron kasi tayong iba't ibang kinds of bail. Okay? We have the surety. Okay? Bail is yung parang ibabayad mo para lang makasiguro sila na hindi ka tatakas or a-attend ka or magpapakita ka or meron kang appearance every time na meron kayong trial. Okay? Next, Rule 115, rights of accused. This rule enumerates the rights of a person accused of an offense which are both constitutional as well as statutory, save the right to appeal which is purely statutory in character. Then 116, arraignment and plea. Ano ba ang arraignment? The formal mode of implementing the constitutional right of the accused to be informed of the nature of the accusation against him. Okay, sasabihin lahat ng constitutional right ng accused and i-inform siya kung ano ba yung inaakusa sa kanya. Plea, the matter which the accused on his arraignment alleges in answer to be charged against him. Okay? Yung plea is yun yung guilty or not guilty. Tatanungin ka. Siyempre, alangan mo't nga ibagam nga guilty. Diba? Doon tayo sa not guilty. Okay? Then, next, Rule 117, motion to quash. This presupposes that the accused hypothetically, guys, hypothetically admits the facts alleged. Hence, the court, in resolving the motion, cannot consider facts contrary to those alleged in the information or which do not appear on the face of the information except those admitted by the prosecution. Okay? Hypothetically daw, inadmit niya yung mga facts na, okay, sinasabi sa kanya or yung mga ginawa niya. Then, pre-trial. An informal trial which precedes the regular trial of a case primarily intended to expedite the processing whenever the accused and his counsel agree, whereby the court shall then conduct a pre-trial conference within the rights of the accused. So, pre-trial, Rule 118. Next, we have the so-called Rule 119, trial na. The examination before a competent tribunal according to the laws of the land of the facts put in issue in a case for the purposes of determining such issue. So, ayan na po yung tinatawag nating trial. Diyan na po magsisimula. Then, judgment. The adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition of the proper penalty and civil liability provided by the law. Ayan na yung sasabihin ng judge or yan na yung final verdict niya. The judgment. Kung guilty ba siya or not guilty. Then, Rule 121, new trial or reconsideration. New trial, the hearing of a case already decided but before the judgment of conviction therein rendered has become final, whereby errors of law or irregularities are expunged from the record or new evidence is introduced or both steps are taken. So, magkakaroon sila ng new trial or reconsideration kasi sinasabi ng kabilang partido na merong mga irregularities. Okay? Merong mga errors. Okay? Dun sa mga evidence na pinakita nila. Then, a motion for reconsideration of the judgment may be filed in order to correct errors of law or facts in the judgment. It does not require any further proceeding. Next, we have the so-called Rule 122, appeal. Aapila po sila, a proceeding for review by which the whole case is transferred to the higher court for a final determination. Kunwari, nagkaroon na ng verdict sa RTC and then hindi sila na-satisfied. Okay? Itataas po nila sa Court of Appeals. Aapila sila doon. And then nagkaroon ulit ng judgment sa Court of Appeals. Hindi pa rin na-satisfied yung offender or yung kabilang partido. Iaakyat nila ngayon sa SC o yung tinatawag nating Supreme Court. Once na nagbigay ng judgment or final verdict yung sa may SC, ibig sabihin tapos na. Okay? Kapag sinabing guilty and then tapos na, wala na silang pwedeng apilahan pa because ang pinaka-higher court is SC or the Supreme Court. Okay? Meron din naman tayong MTC and Municipal Trial Court, Municipal Circuit Trial Court, RTC, Regional Trial Court, then CA, Court of Appeals, and then SC, Supreme Court. Okay? Next, Rule 123. Procedure in the Municipal Trial Courts. Rule 124 naman, procedure in Court of Appeals, and then 125, procedure in Supreme Court. So, see guys, municipal, okay? Next, Rule 126, search and seizure. The term search as applied to searches and seizures is an examination of a man's house or other buildings or premises or of his person with a view to the discovery of a contraband or illicit or stolen property or some evidence of guilt to be used in the prosecution of a criminal action for some offense with which he is charged. Okay, yan po yung ibig sabihin ng seizure. Examination of a man's house or other buildings. A seizure is the physical taking of a thing into custody. Ayan yung pagkuha nila ng physical na. Search kasi maghahanap pa lang sila. Pero kapag search and seizure, ayan na yung maghahanap and then kukunin na nila yung bagay doon sa custody ng tao na yon. Next, we have Rule 127, Provisional Remedies in Criminal Cases. Next, Section 1, Concept of Evidence. What is evidence? Evidence is the means sanctioned by the rules of court or ascertaining in a judicial proceeding the truth respecting a matter of fact. Okay? Alam niyo naman na kung anong ibig sabihin ng evidence, guys. Evidence versus proof. Proof is the effect or result of evidence. Okay? Meron ka na kasing proof, meron ka ng basihan. While evidence is the medium of proof. When the requisite quantum of evidence of a particular fact has been duly admitted and given weight, the result is called the proof of such fact. Every evidential question involves the relationship between the factum probans and the factum probandum. Okay? Parang cause and effect lang yan. The evidence and proof. Next, factum probandum. The ultimate facts or truth to be established. Ultimate fact or factum probandum, principle determinate, and constitutive facts upon the existence of which plaintiff cause of action rests. Does not refer to the details of probative matter or particulars of evidence by which these material elements are to be established. Propositions to be established necessary hypothetical. It may be ascertained in pleadings submitted by the parties or pre-trial order, or issues which are tried with the express or implied consent of parties in Section 5 of Rule 10. Ang factum probans naman, the material. Okay? Material evidencing the proposition. It is the act by which the factum probandum is established. Ayan na yung material, yung ebidensya mo, yung nakikita. Okay, evidentiary facts or factum probans, facts which are necessarily in determination. Yan ang ibig sabihin or yan ang pagkakaiba ng factum probandum, factum probans. Okay, ang factum probandum tinatawag din siyang ultimate fact, and factum probans tinatawag din siyang evidentiary facts. Okay? Oh, so this eto na yung last slide. So thank you, and please like and subscribe, guys. Thank you.